Liberty is doomed where power is united, consolidated in the same hands. That's the warning we got from the Oracle, the celebrated Montesquieu, about separation of powers. This was one of the biggest battles between the Federalists and the Anti-Federalists. But here's the twist. Both sides often use the exact same words from Montesquieu to support opposite arguments, opposite conclusions. So on this episode, we're diving into this critical debate over the ideas of the most cited political writer of the ratification debates, Montesquieu. But first of all, before getting to that, welcome and thank you for joining me here on the path to liberty. My name is Michael Bolden with the 10th Amendment Center, and this is the show for Monday, December 9th, 2024. And here from Rob Nadelson, he points out that Montesquieu's greatest work was The Spirit of the Laws. You could also find it listed as The Spirit of Law. It was composed mostly between 1744 and 48, then published in the latter year and reissued in 1750. It was very popular amongst the old revolutionaries throughout the American colonies. And this from Paul Merrill Sperlin, and Montesquieu and the American Constitution. He said colonials and later Americans were surprisingly well acquainted with Montesquieu. This book in English was early for sale in Charleston in 1756, Annapolis in 1762, Williamsburg in 1765, and in Boston certainly by 1771. It was a better seller in the colonies in 1774. The books of Montesquieu were in libraries of leaders he writes, such as Benjamin Franklin, John Adams, Thomas Jefferson, James Wilson, John Witherspoon, John Marshall, many others. He said, to judge by the numerous citation of the spirit of laws in their papers and speeches, many other influential Americans, including George Mason, James Otis Jr., John Dickinson, Samuel Adams, Nathaniel Chapman, Richard Henry Lee, Edmund Randolph, Alexander Hamilton, James Madison, and others, were familiar with the masterpiece. And by 1787, when we're talking about the Philadelphia Convention and then the ratification debates in 1787 into 1788 over whether or not to ratify the Constitution, The Spirit of Laws really became an American classic. It was really, really studied all over. Here from the Center for the Study of the American Constitution, they point out that Montesquieu's work was the most cited of any political writer at the Philadelphia Convention and throughout the ratification debates. Blackstone was a close second-ish, but nowhere close for people like John Adams or John Locke, Algernon Sidney, and many others. So this was the number one. And at the Philadelphia Convention, I believe the only book that was actually cited more than Montesquieu, not a political book for most people, was the Bible. But let's kick it off here from Book 11. This is a very important book for this particular debate. And here Montesquieu writes, to prevent the abuse of power, it is necessary that by the very disposition of things, power should be a check to power. This is the famous American system of checks and balances, separation of power. This is kind of the foundation right here. A government, he said, may be so constituted as no man shall be compelled to do things to which the law does not oblige him, nor forced to abstain from things which the law permits. And back to Rob, he says, the Montesquieuian feature cited most frequently, and as I mentioned, is the document's separation of powers in the Constitution into three branches: legislative, executive, and judicial. Of course, there were separation of power discussions going way, way back. John Locke, of course, in more recent times, at least to the founders, thought of kind of a two-way separation of power, but Montesquieu is really the guy that they credit with this tripartite system. And here from chapter 6 in that same book, he said, in every government, there are three sorts of power: the legislative, the executive in things in respect to things dependent on the law of nations, and the executive in regard to things that depend on the civil law. So he further breaks that down a little bit further, so you get a little bit more of an understanding of what he's talking about. He said, by virtue of the first, the prince or magistrate enacts temporary or perpetual laws and amends or abrogates those that have been already enacted. That's the legislative power. By the second, we're talking about the executive. He makes peace or war sends or receives embassies, establishes the public security, and provides against invasions. And by the third, he's still kind of talking about executive power, but it's a little different. He punishes criminals or determines the disputes that arise between individuals. The latter we shall call the judiciary power, and the other simply the executive power of the state. Now, no matter what the form of government, any type of government, Montesquieu, it doesn't matter, any type of government, Montesquieu argued that liberty is going to be absolutely destroyed if these three powers are not separated. For example, he said there can be no liberty where the legislative and executive powers are united in the same person or body of magistrates. So it's not just a single person that he's talking about. And he explained why. He said, lest the same monarch or senate should enact tyrannical laws to execute them in a tyrannical manner. It's about dangerous incentives and motives. If you give someone the power to create a law that they're the ones that they're going to be able to enforce that law or implement or execute that law, they may enact bad ones in order to do the bad stuff that they want to do. It's going to draw that type of person into power. And you can see some examples of this. James Madison discussed the power of declaring and waging war in Political Observations in 1795, talking about separation of power. He said the separation of the power of declaring war from that of conducting it is wisely contrived to exclude the danger of it being declared for the sake of its being conducted. And again, he said the separation of the power of raising armies from the power of commanding them is intended to prevent the raising of armies for the sake of commanding them. And you can see how Madison's philosophy about this under the Constitution is certainly influenced by the type of warnings that he learned from his friend, the Baron Montesquieu. He said the separation of the power of creating offices from that of filling them is an essential guard against the temptation to create offices for the sake of gratifying favorites or multiplying dependents. Sounds kind of familiar, at least a little bit right there. Now then, if you go back to Montesquieu, he points out that there is, again, no liberty if the power of judging be not separated from the legislative and executive power. So legislative, executive, and judicial all need to be separate. And then, well, in this situation, he's basically describing Judge Dredd, the power of judging and, well, executing the law all at the same time, if you're familiar with those old movies. And now if you combine all three into one, not just two of them, all three into one, you've got a great big party for lovers of the monster state, of total tyranny, of total despotism. And he said, were it joined with the legislative, back to the judicial, were it joined with the legislative, the life and liberty of the subject would be exposed to arbitrary control. For the judge would be then the legislator. Were it joined to the executive power, the judge might behave with all the violence of an oppressor. And that really is the Judge Dredd version right there. And here's that big party for lovers of the monster state. He said there would be an end of everything where the same man or the same body, whether of the nobles or of the people, to exercise those three powers, that of enacting laws, that of executing the public resolutions, and that of judging the crimes or differences of individuals. And we can see this kind of principle throughout some of the kind of Revolutionary era state constitutions. Here, Virginia in 1776, this is literally right at the top. The legislative, executive, and judiciary department shall be separate and distinct, so that neither exercise the powers properly belonging to the other, nor shall any person exercise the powers of more than one of them at the same time, except that the justices of the county courts shall be eligible to either house of assembly. That's one kind of crossover that they certainly allowed there. And then in the Massachusetts Constitution of 1780, this is John Adams's one, this is literally the last clause in the Declaration of Rights. So you generally don't think of separation of power or delegated and reserved power, descriptions of kind of the structure, rule of construction of how to read power as a part of a Declaration of Rights or a Bill of Rights. But the founding generation certainly saw the right to local self-government as incredibly important as well. And here from, again, that Commonwealth of Massachusetts Constitution, in the government of this Commonwealth, the legislative department shall never exercise the executive and judicial powers, or either of them. The executive shall never exercise the legislative and judicial powers, or either of them. The judicial shall never exercise the legislative and executive powers, or either of them, to the end it may be a government of laws and not of men. Because when you give them these perverse incentives, you end up with a government of, well, people with power. Men with power is really what John Adams and company were getting at right there. Now, I discussed this in an article a couple of years ago, separation of powers, a dogmatic maxim in the Constitution. And here's a brief take from that. Much of the debate over ratification revolved around a question over what qualified as a separation of powers. Everyone was on board with these principles. Everyone agreed. You really didn't find anyone in the ratification debates were saying, oh, that Montesquieu, he's so dumb. I mean, later on, Thomas Jefferson, and if you're really interested in this, Thomas Jefferson wasn't a fan of everything that Montesquieu had to say, unlike some other people. And he certainly spent a lot of time writing about that in some letters where he's saying, oh, Montesquieu, some of his other principles will lead towards kind of a monarchical system. And maybe that's why my Federalist opponents love it. But that's a different take. Everyone was on board with this idea that there can be no liberty unless you have a separation of these powers. And back to my article, I wrote that the question was not whether the Constitution would embody the separation of powers to at least some degree, since few denied this at all, but rather whether the separation was adequate to prevent consolidation, centralization of power, destruction of liberty, tyranny. And that was really the big debate. Here, Richard Peters, in a letter to John Adams, and this is very important because everyone was on board with Montesquieu, and everyone cited the exact same phrases from Montesquieu's book on this to talk about separation of powers. But they came to different conclusions. And here, Richard Peters, in a letter to John Adams, he said, the sentiments of Montesquieu on the subject you mentioned, this was separation of powers, in a previous letter, have indeed been miserably construed. He is a kind of Bible for politicians, and it fares with his as it does with the good book. Everyone finds a text to suit his own purposes. If indeed the text does not exactly fit, convenient interpretations must do the business. Man, we've lived with that kind of stuff on all kinds of issues forever. Here from the Bill of Rights Institute, where let's look at the Anti-Federalists. They point out that during the ratification debates from 1787 to 88, some critics, the Anti-Federalists, this was a term of propaganda, that phrase, but I'll use it just so everyone is kind of on board or understanding who we're referring to. The Anti-Federalists didn't call themselves Anti-Federalists. They felt they were on board with federalism. They were the real Federalists, and the so-called Federalists were the ones that, well, were looking for more consolidation, centralized power, more energetic government is how they described it. But anyways, some critics charged that upon close inspection, the separation of powers in Articles 1 through 3 of the Constitution were not as complete as Montesquieu appeared to advocate and would tend toward an accumulation of power in one branch or another over time. The president, for example, has the power to accept or reject a bill duly passed by Congress, a seemingly legislative power. And in fact, Impartial Examiner, who I'll cite on this in just a few minutes, specifically referred to the veto power as part of the legislative duty and also kind of a kingly type of a power. For its part, the Senate may approve or reject a presidential appointment to his own branch, a seemingly executive power. I mean, they're putting that kind of soft there. The Anti-Federalists are saying, oh yeah, these are definitely mixing the powers, and very much so in the Senate. Even John Adams was not a fan of how the Senate was kind of mixed between the various three powers. But anyways, here, Richard Henry Lee, in a letter to Governor Edmund Randolph in Virginia, this is just weeks after the end of the Philadelphia Convention in 1787, and he says, from Moses to Montesquieu, the greatest geniuses have been employed on this difficult subject of how to make government good, if that's possible at all. And yet experience has shown capital defects in the systems produced for the government of mankind. So he's noticing that all through history, we got all these geniuses trying to improve on things, but yet there's still defects. I mean, that would make us think another thing as well. But he says it has hitherto been supposed of fundamental truth that in governments rightly balanced, the different branches of legislature should be unconnected, and that the legislative and executive powers should be separate. But, and here's the caveat, he's like, well, we got a problem here. He said, in the new Constitution, the President and Senate have all the executive and 2/3 of the legislative. And in some weighty instances, like as making all kinds of treaties, which are to be the laws of the land, they have the whole legislative and executive powers. So we don't often think of it like this, but the Anti-Federalists, people like Richard Henry Lee and others, were saying, look, maybe this is just a small piece, but certainly you're mixing them. And we're all taught, we all believe in this very religiously. We believe in this idea of separation of powers, and now we're not separating the powers. He said they jointly appoint all officers, civil and military, and they, the Senate, try all impeachment. So this is also saying that the Senate has some judicial power, either of their own members or of the officers appointed by themselves. That's Richard Henry Lee, October 16th, 1787, to Governor Edmund Randolph. That will be linked to in the show notes, along with all the original source documents and articles and essays and stuff that I'm going to be citing in this episode. Alan Mosley does a great job getting a blog post for every episode organized, where there's a show link section and also a section that includes all the various platforms. We're on, of course, the mainstream video platforms that we live stream on, like YouTube and Facebook and X and LinkedIn and Twitch, and I don't know, I'm probably missing one, but also we also have the audio-only podcast edition on all the platforms possible. We have the video podcast is now over on Spotify for the past couple of weeks as well, so I appreciate everyone following us there. So Alan will get that organized. Make sure to check out his show, It's Too Late, as well this week, and I will get that published a couple of hours after the live stream is done. 10thamendmentcenter.com/path to liberty. Anyways, let's get back to these anti-federalist arguments about the proposed Constitution, the Constitution for the United States, at least at the time, the proposed one, about mixing powers, violating the principle, the maxim of separation of powers. Here's Sentinel in his second Anti-Federalist essay. He was specifically referring to the Senate as partly legislative and partly executive. He said this mixture of the legislative and executive, moreover, highly tends to corruption. The chief improvement in government, now again, not making it, trying to make it sound too awesome or anything, the chief improvement, he said, in modern times has been the complete separation of the great distinctions of power, placing the legislative in different hands from those which hold the executive, and again, severing the judicial part from the ordinary administrative. And then he cites Montesquieu. When the legislative and executive powers, says Montesquieu, are united in the same person or in the same body of magistrates, there can be no liberty. There isn't going to be some. They're saying it will be none. And whether it happens immediately or a long period of time, if you're thinking long game, eventually there's going to be a consolidation, centralization of power, which, as Patrick Henry warned over and over about in the Virginia Ratifying Convention, is the most destructive thing to consider. It will guarantee the destruction of liberty, he said. Here we are. This is, who is this one? I got to scroll up. I'm not sure. Oh, this is from the dissent of the Pennsylvania, the minority of the Pennsylvania Convention. Let's see if I can get to my notes here. Just scrolling up here for a moment. It's a long one. They're talking about the President General dangerously connected with the Senate. His coincidence with the views of the ruling junto in that body is made essential to his weight and importance in government, which will destroy all independency and purity in the executive department. So there were a couple of dozen anti-federalists that really lost the ratification vote very easily in Pennsylvania. It was like 46-25, something like that. And the Federalists were very aggressive, kind of blocking them from publishing some of their objections in the journals. They actually used some kind of a cancel culture approach on local printers, saying, well, if you run this, we're going to all organize and they're going to drop your subscription. We don't want to see any of these anti-Federalist objections. But most of them, other than just a couple of them, decided to put their kind of thoughts together in papers and in pamphlets, and it did eventually get printed, and it was actually published in various states. So this was a very influential anti-Federalist one-time essay, The Dissent of the Minority of the Pennsylvania Convention. This is a December 18th, 1787 publication, and they're talking about how the president and the Senate, the ruling junto in the Senate, are dangerously connected. And having the power, they write, of pardoning without the concurrence of a council, he may screen from punishment the most treasonable attempts that may be made on the liberties of the people when instigated by his coadjutors in the Senate. Or, well, I guess elsewhere is really how it's played out as well. But they say, again, such various, extensive, and important powers combined in one body of men are inconsistent with all freedom. The celebrated Montesquieu, again, they all agreed that this guy was on to something. He tells us that when the legislative and executive powers are united in the same person or in the same body of magistrates, there can be no liberty, because apprehensions may arise lest the same monarch or senate should enact tyrannical laws to execute them in a tyrannical manner. They're literally using the exact same phrase that the Federalists will use in the Federalist Papers and elsewhere. Now, Impartial Examiner, as I mentioned a few minutes ago, really said the veto power was mixing legislative and executive. If the powers were really, really separate, the executive branch would have no say on whether or not something became a law, because that's for the legislative branch. All it would be able to do is, well, just execute it. That's it. Anyways, he wrote, "Let the free citizens of America, consulting their true national happiness, wish for no innovation but what is regulated according to the scale of equal liberty, or which may not destroy that liberty by too great a share of power being lodged in any particular hands." He said, let this collateral jurisdiction, which constitutes the royal negative. They looked at this type of a power. Many of the anti-federalists looked at the veto power as being a kingly power, and they didn't like it. He said, let this be held by kings alone, since with kings it first originated. Let this remain in its native soil, as most congenial to it. There it will cumber less and be more productive. Here it will be an exotic and may poison the stock in which it may be engrafted. Now, Mike Meharry, in a recent article on George Mason's anti-federalist objections, pointed out that Mason was also concerned about mixing powers. Mason, he said, worried that these, along with its other great powers, talking about the Senate, including the appointment of ambassadors, its role in making treaties, and the power to try impeachments. Again, trial of impeachment is saying that the Senate has judicial power in very limited situations, but it does. And many people, now maybe you think the anti-federalists are crazy, they're being too hardcore. That may be the case, but this is the argument that was being made. This would, he said, destroy any balance in that government and enable them to accomplish what usurpations they please upon the rights and liberties of the people. Patrick Henry warned that partly because of this part of the legislative branch having judicial power, that the impeachment power would be a sham. Maybe he was onto something. Mike Meharry writes that fundamentally, this objection was rooted in George Mason's belief that the proposed operation of the Senate violated the principle of separation of powers, and his anti-federalist objections were really some of the first that got widespread attention. Mike said this mixing of powers between the branches became another common anti-federalist argument. Hear from John C. Pinheiro over at Law and Liberty. He points out the Federalist side. Federalists like James Madison and Alexander Hamilton also quoted and heavily used Montesquieu. Federalist number 47, and then all the way to 51. Really, we're talking about separation of powers here from Madison and Hamilton a little bit too. But Federalist 47 from Madison is one long disquisition on Montesquieu and how Americans ought to interpret the ways he connected liberty to separation of powers. Hear from James Madison. This is in Federalist 47. He's pointing out that his opponents, the Anti-Federalists, they certainly were citing Montesquieu, and it was a very powerful argument because the general public was also very aware and very much on board with these principles. And Madison said one of the principal objections inculcated by the more respectable adversaries to the Constitution, and that is kind of a jab right there. Some of you guys are worthless, and that's kind of the mentality you heard from a lot of the Federalists. Madison should have been above that, but I guess he was not. One of the principal objections inculcated by the more respectable adversaries to the Constitution is its supposed violation of the political maxim that the legislative, executive, and judiciary departments ought to be separate and distinct. He's right off the bat here in Federalist 47 saying, oh, well, these guys are reading this wrong. This is how you're supposed to read. He said no political truth, first of all. He's on board with his opponents that if the principle's violated, then the whole system should be thrown out. He said no political truth is certainly of greater intrinsic value or is stamped with the authority of more enlightened patrons of liberty than that on which the objection is founded. So you objectors on separation of powers, I agree with you on the principle that you're talking about. You're just reading Montesquieu wrong. He says the accumulation of all powers, legislative, executive, and judiciary in the same hands, whether one, a few, or many, and whether hereditary, self-appointed, or elective, may justly be pronounced the very definition of tyranny. Now, he points out, okay, let's look at this. Let's look and see what Montesquieu had to say. He said, in order to form correct ideas on this important subject, it will be proper to investigate the sense in which the preservation of liberty requires that the three great departments of power should be separate and distinct. The oracle, this was a common term for him. The celebrated Montesquieu was a common term for him. And we know that Montesquieu had been writing letters back and forth with people like George Washington, James Madison, and many others. The oracle, he said, who is always consulted and cited on this subject is the celebrated Montesquieu. Now, he, in this same book, he's not right at the beginning, but he talks about how he's praising the British system, the British Constitution, the unwritten system, its separation of powers doctrine in England. Of course, the French weren't too happy with this Frenchman who was praising the British system, but that's another story. And Madison continues, the British Constitution was to Montesquieu what Homer had been to the didactic writers on epic poetry, as the latter, basically the best of the best, as the latter have considered the work of the immortal bard as the perfect model from which the principles and rules of the epic art were to be drawn, and by which all similar works were to be judged. So this great political critic appears to have viewed the Constitution of England as the standard, or, to use his own expression, as the mirror of political liberty. And certainly, Madison may be kind of taking a little bit liberty with how he's describing this, but he is correct. Montesquieu certainly praised the British Constitution, praised the British system, and then went on to discuss separation of powers. And back to Madison, he said, well, because of this context, if we're reading him with context, now he doesn't specifically say one way or the other, complete separation or partial separation. Montesquieu never actually said one or the other. So they are reading it in context, interpreting it in ways just the way that letter to John Adams, who was that again? I forget who wrote that. Richard Peters sent to John Adams saying, when it's not super clear, people in politics are going to just read it in ways that fit their own narrative. And now maybe Madison is doing this. Maybe he's got confirmation bias. Maybe he's being honest. Maybe he's lying. I don't know. And maybe the other side, it's the same thing. We don't really know. That's why I'm just kind of trying to share these views with you, and you can make up your own mind. He says, on the slightest view of the British Constitution, this is back to Federalist 47, we must perceive that the legislative, executive, and judiciary departments are by no means totally separate and distinct from each other. So Montesquieu is saying, well, you got to separate them. And at the same time, the British Constitution is the best of the best ever in history. So, but they're not totally separate. So doesn't that mean that we don't have to be totally separate either? The executive magistrate forms an integral part of the legislative authority. He alone, writes Madison, has the prerogative of making treaties with foreign sovereigns, which, when made, have under certain limitations the force of legislative acts. So the executive had some legislative power in some narrow areas. He said all the members of the Judiciary Department are appointed by him, can be removed by him on the address of the two houses of Parliament, and form, when he pleases to consult them, one of his constitutional councils. So the Judiciary Department, according to Madison, also plays part of the Executive Department in some situations. He says one branch of the Legislative Department forms also a great constitutional council to the executive chief, as on another hand, it is the sole depository of judicial power in cases of impeachment, and is invested with the supreme appellate jurisdiction in all other cases. Again, versions of how this power was blended over and over and over in the British system, which everyone understood that Montesquieu praised over and over. So, but was he praising the exact nature of it? We don't know. He said Madison then rejects the idea that there has to be a complete separation of power. I believe, as Sentinel put it in his second essay, which I cited a few minutes ago, he said he did not mean that these departments ought to have no partial agency. And if you're looking up on the screen, there's some all caps here. This isn't just for email forwards from your great uncle or anything like that. And by great uncle, I mean your awesome uncle, since I'm one of those. He did not mean that these departments ought to have no partial agency in or no control over the acts of each other. His meaning, as his own words import, and still more conclusively as illustrated by the example in his eye, can amount to no more than this: that where the whole power of one department is exercised by the same hands which possess the whole power of another department, the fundamental principles of a free constitution are subverted. That's James Madison, Federalist number 47. William Davey. There are many other examples of similar takes from the Federalist side, just like there are many other examples on the Anti-Federalist side of some of the examples I gave. Here's William Davey in the North Carolina ratifying convention. He said, "It is true, the great Montesquieu and several other writers have laid it down as a maxim not to be departed from, that the legislative, executive, and judicial powers should be separate and distinct. But the idea that these gentlemen, his opponents, the antis, had in view, has been misconceived or misrepresented. An absolute and complete separation is not meant by them. It is impossible to form a government upon these principles." Now, here's the important point, and I mentioned it already. Montesquieu actually didn't say complete, partial, when it came to separation of power at all. So both sides were actually just interpreting it. I don't know. Montesquieu, first of all, back to Davey. Montesquieu, at the same time that he laid down this maxim, was writing in praise of the British government. At the very time he recommended this distinction of powers, he passed the highest eulogium on a constitution wherein they were all partially blended. In other words, this is an awesome constitution. They're all partly mixed or partially blended. And if he's saying that, then why would we think that he really meant complete separation? He said, so that the meaning of the maxim as laid down by him and other writers must clearly be that these three branches must not be entirely blended in one body. Now, again, back to Montesquieu. He points out that at the end of this is the end of chapter 6 in book number 11. He actually points out this: "It is not my business to examine whether the English actually enjoy this liberty or nor. Sufficient it is for my purpose to observe that it is established by their laws, and I inquire no further." So one might read this and say, well, he's not actually saying that the British version of what the British are supposed to have established by their laws is being implemented the way it's supposed to be implemented. Now, maybe I'm reading that out of context, but I think that's how some people were reading it. He's not saying that just because it's played out in practice different than how I described, that I'm praising what's playing out in practice. On the other hand, he didn't actually say that either. So again, we're getting down to interpretation. And I think that analogy with the Bible is a pretty good one. James Wilson in the Pennsylvania Ratifying Convention makes a good point on the Federalist side. He said, "We are told by honorable gentlemen that those three branches of government are not kept sufficiently distinct in this Constitution. We are told also that the Senate, possessing some executive power, as well as legislative, is such a monster that it will swallow up and absorb every other body in the general government after having destroyed those of the particular states." He said, is this reasoning with consistency? Can this body be so tremendous as the present Congress? Now he's saying like, oh, well, if you guys are super on board with the separation of powers thing, you better move forward with ratifying this Constitution, because at least this is way further in that direction than what we have under that garbage Articles of Confederation, where it's totally mixed and blended powers. And that's his argument here. He said, can this body be so tremendous as the present Congress that is under the Articles? A single body of men possessed of legislative, executive, and judicial powers. I would argue against them having, I guess, some executive. They certainly had judicial powers in very kind of a lengthy, unique process in some narrow situations. And it certainly, of course, they had legislative powers. They did not really have the power to enforce anything. But it certainly was much more blended in that single body. He said, to what purpose was Montesquieu read? To show that this was a complete tyranny. Never heard any arguments about that, did we? Said James Wilson. He said the application would have been more properly made by the advocates of the proposed Constitution against the patrons of the present Confederation. Now, that is Wilson was a really smart guy. And on some things, he was really, really good, but he was also a big government guy. He did want to see a singular kind of a national system rather than a union of states. He was definitely more towards the Hamiltonian ends of things, even though not as bad as Alexander Hamilton in his goals. But he was also a really top lawyer, a top legal mind at the time. He was a very good debater and arguer and presenter. So, that's kind of an approach here. He's not actually focusing on the argument at hand. He's like, well, if you got a problem with this, why didn't you have a problem with that? That is a misdirection. So we might look at him poorly on this, but maybe he had a good point. Now, back to my article. He said, that Bolden dude said, James Madison considered the separation of powers so important that he not only called it a dogmatic maxim, he specifically referred to it as that. He expressly included it as part of his proposed amendments for the Bill of Rights. So when James Madison proposed amendments to the Constitution, he didn't call it a Bill of Rights at that point, in June of 1789 and presented and laid it all out in a speech. He wanted to see separation of powers included in the body of the Constitution. In representing, I wrote, the twin pillars making up the foundation of the Constitution. This is how he referred to it. Madison's proposal would have created a brand new Article 7, which would have been a combination of separation of powers and a precursor to the 10th Amendment, delegated and reserved powers, together in the body of the text. And if you think about it, that really makes a lot of sense, because the idea of delegated and reserved powers is also a separation of powers as well. I covered that in much more detail. This was his 16th Amendment proposal, much better than the 16th Amendment that we ended up getting. The other 16th Amendment, separation of powers, that will be linked to in the show notes at 10thamendmentcenter.com/path-to-liberty. And I think the interesting middle ground, as usual, tended to come from John Dickinson. And here from William Redinger over at Liberty Fund. Citing Polybius and other authors and examples, ancient and modern, to augment his argument in Fabius number 4, John Dickinson defended the Constitution's separation of powers, which so arranged the departments of government that they, quote, may therefore be said to be balanced. For Dickinson, it was less about complete separation or partial separation, but more about balance. This is something that would render, quote, the extraordinary interference of the people less frequent. In other words, Dickinson's saying if we get good balance out of this, he also in that same essay said a good constitution could only promote but can't guarantee a good administration. So our goal is to get as good of a balance as possible so we don't have to have a bunch of revolutions all the time. We got to make it less frequent. And anyways, William continued, the importance of the separation of powers notwithstanding, John Dickinson argued that it is ultimately the people, the sovereign authority, the ones with the final say on everything, who must keep watch to preserve the new Constitution, which is to say that political orders are properly and truly balanced by, quote, the power from which they proceed. That really hammers home, in my view, that the real separation of power that can keep government in check is the separation of power between government and the people. And it's ultimately, as Dickinson put it, up to the supreme sovereignty of the people to keep government in check. Now, this is not the type of stuff, if you're like me, you never learned really anything more than maybe a line or two about separation of powers, and it's not discussed much today because whoever has power loves, well, doing whatever they want with that power. And that's why we work so hard every single day here at the 10th Amendment Center to reach and teach more and more people about these essential foundational principles about the Constitution and liberty and how to defend both when government refuses to do its job, which is follow the Constitution, and that almost never happens. It violates the Constitution 24/7, 365. And you can help us in this work, roll up our sleeves every day and get the job done. Nothing helps us more than the financial faith and support of our members. You can join us for as little as $2 a month. If you got a couple of bucks of that dirty government fiat, please consider throwing it our way over at 10thamendmentcenter.com/members. That's all spelled out, 10thamendmentcenter.com/members. We also have annual, 5-year, and lifetime options. You can make a one-time donation over at 10thamendmentcenter.com/donate. And if you don't got any extra loot laying around that you feel comfortable throwing our way, that's cool. But I'd be very grateful to any consideration you can give to joining us today and supporting our work. But you can also support us with a number of free and easy peasy actions like leaving reviews on any of the podcast platforms like Apple or anywhere else, hitting the like button, comments in the archive, subscribing, getting notifications, sharing the links to whatever platform you watch or listen on. All that stuff can help trigger the algorithms of the mainstream platforms and tell them to show us to more people. It helps out a great deal. I hope you enjoyed this episode. I hope it made you think. I hope you learned something that's more important than anything. I hope you had an awesome weekend, and I look forward to seeing you next time here on the path to liberty.